All right, welcome to this explainer. Today, we're diving straight into the ultimate rulebook that governs the daily lives of both employers and workers in Ghana, the Labor Act of 2003, widely known as Act 651. If you've ever had questions about how the workplace actually operates from a legal standpoint, well, this is your master document. So let me ask you this. Do you truly know your workplace rights and obligations? I mean, whether you're running the whole show, managing a team, or clocking in for your daily shift. Understanding your legal boundaries can literally be the difference between a thriving career and an absolute legal nightmare. It's all about empowering yourself with this knowledge so you can operate with total confidence. Okay, let's trace the entire life cycle of employment today. We're going to cover rights, duties, and contracts, pay, leave, and hours, protecting vulnerable workers, unions and dispute resolution, and finally, fair and unfair termination. Starting right off with Section 1, rights, duties, and contracts. It's literally a balancing act here. On one side, as a worker, you've got fundamental rights, things like safe working conditions, equal pay for equal work, and the right to form unions. But, employers have explicitly protected lanes too. They've got the right to discipline workers, tweak business operations, and set those production targets. It makes sense, right? For an enterprise to actually succeed, both sides really need clear, legally protected boundaries. Now, the magic number to remember here is 6. If you've been working somewhere for 6 continuous months, or basically the equivalent of 6 months within a single year, the law steps in. It legally guarantees your right to a formal, written contract. A handshake just doesn't cut it anymore. Within 2 months of starting, your employer absolutely must hand over a written statement that lays out your rights, your obligations, and the whole shebang regarding your employment terms. Moving right along to Section 2, pay, leave, and hours. So, what's the statutory maximum for standard working hours? It's locked in at 8 hours a day or 40 hours a week. Simple as that. But what happens if you go over? Well, the Act is crystal clear. Anything beyond those fixed hours has to be paid out as overtime. And here's the kicker. You actually can't be forced to work overtime unless the very nature of the business requires it to survive or, there's a literal emergency threatening life or property. All right, let's talk about time off. The number to remember here is 15. Every single worker is entitled to an uninterrupted minimum of 15 working days of paid annual leave per calendar year of continuous service. And yes, that is with full pay. Oh, and actually, scratch the idea that holidays eat into this. The Act specifically states that public holidays and certified sick leave do not count against those 15 days. Pretty great, right? Let's quickly clarify what a casual worker actually means under the law. We're talking about someone doing seasonal or intermittent work for less than 6 months, getting paid on a daily basis. Think of a worker hired just for the busy harvest season, or maybe a quick construction gig. But here's why this matters. Even casual or temporary workers have explicit, ironclad rights under this Act. If this is you, you still get equal pay for work of equal value, access to general medical facilities at work, and get this, you're legally entitled to full pay on public holidays. Let's shift gears to Section 3, protecting vulnerable workers. For instance, the protections for pregnant workers and nursing mothers are super specific. They are guaranteed a minimum of 12 weeks of paid maternity leave. Plus, an employer absolutely cannot force a pregnant woman to work night shifts between 10 p.m. and 7 a.m. without her consent. No way. On top of that, nursing mothers get a legally mandated 1-hour interruption every single day to nurse. And yes, that counts as paid working time. And just to be absolutely clear, firing a woman just because she's out on maternity leave is strictly forbidden. But this protective umbrella goes even further. Young workers, they are entirely banned from doing hazardous underground mine work, and employers have to make sure they pass a medical fitness exam before even hiring them. As for persons with disabilities, the Act actually offers special incentives to employers who hire them. And listen to this, if a worker becomes disabled while employed, they can't just be let go. The employer is obligated to try and find a corresponding role or transfer them if at all possible. Okay, moving into Section 4, unions and dispute resolution. Look, disagreements happen. When they do, the Act lays out this mandatory escalating process to handle them. It's kind of like a staircase. Step 1 is good faith negotiation, where both sides try to hash it out based on their collective agreements. If that doesn't work out within 7 days, we step up to mediation, where the commission brings in a neutral mediator. And if that still breaks down, we escalate to the final step, arbitration, where an arbitrator or panel steps in and makes a binding decision. Now, this is where it gets really interesting. The definition of a lawful strike. If arbitration totally fails Or if parties just refuse to do voluntary arbitration, workers can lawfully strike. The catch? They have to give a 7-day written notice first. And during a lawful strike, employers are barred from firing the workers participating in it. However, there is a massive exception to this rule. If you work in life and death essential services, think public health or safety, you are strictly prohibited from striking and must settle things through compulsory arbitration. Overseeing this whole process is the National Labor Commission. They're basically the ultimate referee for industrial disputes in Ghana. And they've got some serious teeth. The commission actually wields the powers of the High Court. That means they can force witnesses to show up, compel the handover of documents, and issue binding orders to squash unfair labor practices right then and there.
Finally, let's wrap up with Section 5, fair and unfair termination.
The law draws a very hard line between fair and unfair dismissals. A fair termination is pretty straightforward. It happens because of incompetence, proven misconduct, legal restrictions, or genuine redundancy. On the flip side, an unfair termination is when someone gets fired for things like union activity, gender, pregnancy, disability, or, and this is a big one, because they filed a complaint against their employer. The law is designed to strictly shield workers from any kind of retaliatory or discriminatory firing. So what happens if the commission investigates and finds a termination was actually unfair? Well, they have some pretty heavy-duty remedies at their disposal. They can order the employer to reinstate the worker, effectively erasing the termination from day one. Or they can mandate reemployment in a different, suitable role. Or they might just order financial compensation to make the worker whole again. And let's say a company shuts its doors, merges, or goes through massive changes that result in redundancies. An employer can't just lock up and walk away. They are legally required to consult with the union or the workers 3 full months in advance. They have to provide written notice and genuinely negotiate a fair redundancy pay package to help cushion the blow for the folks losing their jobs. We've definitely covered a lot of ground today. Having explored this delicate balance of rights and duties under Ghana's Labor Act, how are you going to use this explainer to advocate for yourself or maybe improve how your own organization operates day to day? Because at the end of the day, knowing the law is absolutely your best tool for creating a fairer workplace. Thanks for joining me on this one, and keep pushing for that knowledge.